My name is Constance Boateng, and I am 55 years old. I spent 20 years as a human resources manager, benefits administration, retirement plan enrollment, for 401k compliance, the paperwork that employees sign on their first day and never look at again until the day they need it most. I know what a retirement account beneficiary form is. I know how it differs from a will, from a trust, from every other estate document a person might hold. I know that it supersedes all of them, that a beneficiary designation on a 401k or an IRA will override any instruction in any other document, no matter how recently written, no matter what a judge might think is fair. I knew all of this. When my husband of 16 years died, I assumed I was the beneficiary on his 401k. We had been married 16 years. I had named him on mine. We had never discussed it being otherwise. I was not the beneficiary. His ex-wife was. The woman he had been divorced from for 14 years, who had remarried, who had 3 children with her second husband. Her name had been on that form since the day he enrolled, and no one, not him, not his employer's HR department, had ever changed it. What happened next is not a story about negligence, though negligence is in it. It is not a story about an ex-wife, though she appears in it. It is a story about a woman who had spent 20 years explaining exactly this situation to other people, who now stood inside it herself, and who used what she knew with the particular steadiness of someone who has no other choice. Welcome to Calm Drama Stories. My name is Constance, and this is the channel where what you spent your career teaching others turns out to be the only lesson that matters for yourself.
Subscribe.
Drop your city in the comments. This story starts with a phone call from a benefits administrator and ends with a federal regulation most people have never heard of, and the distance between those two things is 20 years of HR experience and one form I found in a filing cabinet that changed everything. Let me tell you about Gerald. Gerald Boateng was 58 when he died of a heart attack. He was an IT project manager, calm, systematic, the kind of man who documented everything at work and almost nothing at home, which is a pattern I had seen in enough professional men over my career that I should have known to verify rather than assume. We had met 5 years after his divorce from his first wife, Sandra. They had been married for 4 years, had no children together, and had separated amicably, which Gerald described as mutual and clean. Sandra had moved on quickly, remarried within 2 years, built a full life in another state. Gerald spoke of her without bitterness. I had no reason to think about her. Gerald's 401k had been opened at his employer 12 years before we met. He had enrolled on his first day of employment and named Sandra as beneficiary because she was his wife. When their marriage ended, he did not update the form. When we married, he did not update the form. When I spent the first year of our marriage explaining to employees at my own company why they needed to update their beneficiary designations after any major life change, marriage, divorce, death of a prior beneficiary, I did not apply that conversation to my own household. That is the peace I carry. Not blame. Understanding. I knew the principle. I did not verify the application. The call came 6 weeks after Gerald's funeral from his employer's benefits administrator. She was professional and careful, the way HR people are careful when they are delivering information that will hurt. She said the 401k claim had been filed. She said the designated beneficiary had been confirmed. She said there was a process for disputes if I wanted to know about it, and that she was calling as a courtesy. The account held $312,000. I sat with the phone for a long time after she hung up. Then I got up, went to my home office, and started working. What I knew going into this, what 20 years of HR had given me that most people in this situation do not have, was the landscape. Retirement accounts are governed by a federal law called ERISA, the Employee Retirement Income Security Act. Under ERISA, a properly designated beneficiary on a 401k receives the funds directly, regardless of the account holder's will, regardless of a divorce decree, regardless of what any state family law court might determine about marital property. Federal law governs. The designation form controls. This is the thing I had told employees hundreds of times. The designation form controls. But I also knew, because HR professionals who handle disputes know the edges of the law as well as the center, that there was one exception built into ERISA for pension-type plans, and one important federal regulation that had expanded protections for surviving spouses in qualified retirement plans. The regulation was straightforward. For certain qualified plans, a surviving spouse has a legal right to the account unless they have formally waived that right in writing, a waiver that must be signed by the spouse, notarized, and executed with specific language. The waiver is called a spousal consent waiver. I had never signed a spousal consent waiver. I had never been asked to sign one. The question was whether Gerald's plan was the type of plan that required one. I called a former colleague, a woman named Harriet who had spent 30 years in benefits compliance and who was, at 64, the person I called when I needed someone who had seen every version of every situation. She said, "What kind of plan is it?" I told her the employer. She said, "Pull up their plan document. The summary plan description. It should have been provided to Gerald as a participant. Do you have it?" I went to the filing cabinet, the one I kept for household documents, the habit of 20 years in HR where you keep everything because you have watched too many people need documents they no longer have. In the back of the household finance folder, behind the insurance papers and the mortgage documents, was a booklet. Gerald's employer had mailed it to our home 7 years ago when the plan was amended. I had filed it because I file everything. I brought it to the table and read the section on beneficiary designations. The plan document contained the following language in Section 12, Subsection 4. In the event of the participant's death, the qualified pre-retirement survivor annuity shall be paid to the surviving spouse unless the participant has elected otherwise with the written, notarized consent of the surviving spouse. Qualified pre-retirement survivor annuity. The specific phrase that triggers the spousal consent requirement under ERISA. Gerald's plan was a plan that provided a pre-retirement survivor annuity. Under federal law, changing the beneficiary away from a surviving spouse on this type of plan required my written, notarized consent. I had never provided that consent. There was no record of any such consent being obtained. This meant that the beneficiary designation, Sandra's name on a 14-year-old form, may not have been valid for the full account. The plan was legally required to protect my survivor interest unless I had waived it. I called Harriet back. I read her the language. She said, "Constance, you know what that means." I said, "I need an ERISA attorney." She said, "Today." "Not this week, today." The ERISA attorney's name was David Owusu-Afriyie. He specialized in employee benefits disputes and was, when I described the situation to him in the technical language of HR compliance, the most focused I had seen an attorney in a consultation, the specific focus of someone who knows the terrain and recognizes when the facts are favorable. He said, "You have the plan document?" I said, "Yes." He said, "You never executed a spousal consent waiver?" I said, "I was never asked to." He said, "Do you have any documentation, any communication from the employer about the beneficiary designation during your marriage?" I said, "No." They sent the summary plan description. Nothing else. He said, "The plan was required to obtain your consent before honoring a beneficiary designation that named anyone other than you. If they paid Sandra without obtaining that consent, they may have violated the plan's own terms under ERISA." I said, "What does that mean for recovery?" He said, "It means we file a claim. It means the plan administrator has to respond. And it means we have a viable argument that the full pre-retirement survivor benefit is owed to you." He filed the claim within 48 hours. What followed was 4 months of plan administrator correspondence, document requests, and one very uncomfortable reality. Gerald's employer's HR department had failed to flag the change of life status requirement when Gerald married me. When I came onto his benefits as a spouse, no one had audited the beneficiary designation. No one had sent a notice. No one had asked for a spousal consent waiver. This was, David told me, not unusual. It was a compliance failure that happened in benefits administration more often than the people managing the plans would like to acknowledge. Sandra's attorney pushed back. She argued that Sandra had received the designation in good faith, that she had filed the claim correctly, and that the procedural failure belonged to the employer, not to her. David agreed that the failure belonged to the employer. That was, in fact, the argument we were making. Not that Sandra had done anything wrong. but that the plan had paid out a benefit it was not legally authorized to pay without my consent, and that the plan, and therefore the employer, was liable for the survivor benefit I was owed. The plan administrator's legal team took 2 months to respond formally. When they did, their assessment was that the claim had merit. They did not want to litigate a federal ERISA violation. They proposed a settlement. The settlement was structured as follows. The employer's plan would make a separate distribution equal to the pre-retirement survivor annuity value from the plan's error and omissions reserve, calculated based on the plan's actuarial formula for surviving spouse benefits. The amount was $218,000. It was not the $312,000 that Sandra had received. It was the calculation of what the plan owed me under its own terms for its own failure. David said, "This is a fair resolution under the circumstances." Sandra received what the form said. You are receiving what the law says you are owed. The plan is covering the gap from its own compliance failure. I said yes. What I want you to know, if you are married and your spouse has a 401k or a pension, is this. Ask your spouse today to show you the beneficiary designation on every retirement account they hold. Then ask whether the plan is a defined benefit plan or a plan that provides a pre-retirement survivor annuity. If it is, ask whether a spousal consent waiver was ever signed. If it was, ask to see it. If it was not, ask whether your name is on the designation form. Your name should be on the designation form. If it is not, ask why and understand the answer. This is not a difficult conversation. It is a 15-minute conversation that most couples never have because the form was filled out years before the marriage and nobody looked at it again. One action. Today, ask your spouse to pull up their 401k beneficiary designation. If they don't know how, tell them to log into their plan portal or call the HR department. It takes one phone call. It takes 5 minutes. It is the most important 5 minutes in estate planning that most people never spend. Gerald did not do this out of malice. He did it out of the same negligence that most people bring to paperwork they filled out years ago and filed away and never thought about again. He did not think the form mattered. He did not think the name on the form was the name that would receive $312,000. He was wrong. Now you know. The part of this story I have not yet told you is what happened with Sandra. Sandra and I have never met. We have never spoken. Our attorneys handled everything, and once the settlement was reached, there was no reason for us to be in the same room. But her attorney, near the end of the process, sent a note through David, not a legal communication, a personal one. It said that Sandra had been unaware of the designation until she received the call from the benefits administrator. She had not known Gerald had never updated it. She had assumed, reasonably, that a man who had been divorced for 14 years and remarried had updated his own paperwork. She had been wrong about that, too. I sat with that note for a long time. 2 women, neither of whom had done anything wrong. One form, 14 years old, that neither of us had known about. One man who had not tended the paperwork of his own financial life with the same care he brought to his professional projects. I do not feel anger at Gerald when I think about this. I feel the specific exhaustion of someone who spent 20 years telling other people what to do and did not do it herself. I have updated every beneficiary designation I hold. I have a spreadsheet. It lives in the filing cabinet. My daughter knows where it is. The account is settled. The lesson is learned, not borrowed from my career but earned directly. Know the forms. Know the names on them. That is everything.